Interest by Timberlake, League and Brooks, which pays an advertising fee to this station.
This is WAAY 31 Law Call.
Good evening. Welcome to WAAY 31 Law Call. I'm Sharon Dovey. Tonight it's Ask Us Anything night, so we're opening the phone lines up to any kind of legal question. Maybe you've got questions about a car accident. Maybe you've got questions about the way court works or how you go about choosing a lawyer, how you go about paying for a lawyer if you don't have the funds to do that, but you do have a good case. Call in. You can be live on the air with us, 256-536-0077. You can call in, be live, or you can text us to that same number. We've got some text questions have already come in this evening. And you can also email a question on any legal topic any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull some out. We've got some of your email questions for us tonight, too. We've also got Michael Timberlake from Timberlake, League and Brooks. Good to have you here tonight.
I'm glad to be here. Here we go.
Answering anything tonight.
Well, I'm going to ask you if I don't know the answer.
We'll pass it back and forth. We'll figure out something. We'll point you in the right direction, though. While we get some calls locked in, we've got tonight's You Make the Law Call video. This is something we've pulled off of YouTube. Oh, okay, so the guy on the ground had one job. He's just supposed to be holding the bottom of that ladder, and he gets distracted. Thank goodness the guy on the top of the ladder, he's not injured, and he walks away mad, no wonder. But if this had been worse, okay, it looks like it's somebody working there.
Right.
It's an on-the-job injury. Is this a workers' comp case? Would it be, if he were injured, does he have to sue his coworker to get some money out of this, or what does he have to do?
Yeah, I mean, so the interesting part about this is it kind of sets up the dynamic that we see in a lot of situations. So if you are working for someone and you're injured, then you're entitled to workers' compensation. Workers' compensation is a limited remedy. It provides for medical expenses, some payment for time off work, and some limited payment for permanent injury. But it is not a full and complete recovery. And in Alabama, the workers' compensation is, we call it pathetic on a good day.
You're not getting rich off
You're
this.
not getting rich off of it. The major benefit is your medicals. Okay. And so in this situation, if you can, look to somebody that's a third party or somebody that's not working with you or for the same employer, make them responsible, then you can get full compensation for your injuries. In this situation, it looks like the guy that was with him was a co-employee. He was a guy, somebody was just, and he was negligent, didn't do what he was supposed to do. But in this situation, you're going to be limited by the Workers' Compensation Act to, co-employees. In Alabama, co-employees can only be responsible for basically intentional, or just uber reckless conduct. It's really, really, really tight window to making them, co-employee.
This doesn't look like uber reckless.
No,
he's distracted.
It's not going to get there. If you're riding around in a car with somebody who's drunk, and you didn't know it, that's one thing. If they remove a safety guard from a machine, and you take your hand off or something like that, that's another type of thing. But it's really, really limited in Alabama.
Okay. So we have already gotten in some text questions, and we're watching for your calls to come in. So we got a question from Carolyn tonight. Carolyn says she watches every week. Thank you, Carolyn. Thank you for saying that. She's got some land, 3 acres in Kentucky, and a neighbor, I think she wants the neighbor to give her an easement to get into her property.
Right, gotcha.
It's a little bit confusing whether she wants the easement or whether they're wanting an easement across her property. Talk a little bit about easements. If you've got some land and you need to get into your land, or you just like a better route to get into your land, what are your rights with that?
Right. Well, I mean, first of all, if your land is landlocked, if your land is isolated and on all sides by other land, and there is no way for you to have access to your property except by going over someone else's property, then most states, I'm sure Kentucky wouldn't be included, would allow you to have a prescription, easement by prescription, which means basically you have a right to access over somebody else's land, to access your land because you don't have any way to get to your property other than going over their property. Now, typically, when you look at that, the routes are going to be in consideration. What were the traditional routes, this, that, and the other? What's the least restrictive, least intrusive way on your other, adjacent landowners to allow you to access? But otherwise, you're going to look at you're either going to have to pay for an easement or pay for access over a driveway. A lot of neighbors have like a shared driveway where you pay for expenses. That's going to have to be something that they would have to agree to, that you would have to agree to with your neighbor. But if you absolutely, unless you're just absolutely landlocked, you're not going to be able to force somebody to give you an easement.
You'd say whatever you do, get it in writing, wouldn't you?
Oh yeah, absolutely.
Get a legal document
Absolutely.
that they can't
Well, and that
change
protects
it
both
later.
people.
Yeah.
You say you know what the rules are.
Yeah. We've got Michael on the line with a question from Higdon. Hi, Michael. Thanks for calling. What's your question tonight?
Yes, I need to know what I can do. I work for this person, and I just got $25 out of 12 weeks. What can I do about that?
So they've paid you $25, and you think that you should have been paid way more than that?
No, yes, and I ain't got paid but $25
Okay.
out of the 12 weeks.
12 weeks worth of work
Right,
at
right.
$25. What can you do?
You working 40 hours a week?
No, like 4 to 7, 8 hours a day.
Right, right. Well, I mean, if you're employed, doing any kind of work in Alabama, you're entitled to, minimum wage, basically. You can, work on a contract that's less than minimum wage, depending upon, what you want to negotiate. So if you're an adult and you bid on a job and it takes you a lot longer to do it than you thought it was going to do, and you'd agreed to accept a certain amount, that's one thing. But if you're an employee and you're working, hourly for someone, then they have to pay you at least minimum wage for the work that you do.
Okay. We got a text question in. Somebody's asking about a married couple. Husband inherits a house. They move in. They get an air conditioning unit with both of them financing that. Then they divorce. It's uncontested. She leaves the property, so wife leaves the property. Should he, husband, be responsible for the unit, that air conditioning unit, since he still lives there? So I do family law.
That's a good question for Sharon.
It's a good question I can work on. If it's an uncontested divorce, boy, I hope you got that written in somewhere. So if you're both obligated on the debt, but you didn't write it into the divorce agreement saying he's going to be responsible for that, she can still wind up getting hit with having to pay those fees. So if you're ever going through something like that, normally the agreement would be whoever's keeping the property, whether it's a car or a house, keeps the debt that's associated with that. So if you get to keep the Tahoe, you get the debt on the
Right.
Tahoe, and that makes sense, right?
Well, and that's what, divorce is an equitable division of assets. So it doesn't have to be equal, and the judge, and if it's ultimately tried at the end of the day, the judge would look at the situation and they would say, okay, you've made some payments on it, but you got the benefit of that. You're not going to get, ultimately, the unit, but you did get some benefit. You shouldn't have to pay for the whole thing, though.
Happens a lot with furniture. People with buying that high-priced furniture when they get married and they realize, oh, it's not really worth $10,000. Got this email question. Can you explain probable cause as it applies to searching your car during a stop? Do cops have to actually see something illegal, or can they just search because they suspect something? And that's from Pat.
Yeah, that's a that go back, that's a serious constitutional law question. And really what what the law says is that if a police officer has reasonable suspicion to think that a crime has occurred, then they have the ability to detain someone, talk to them about that situation. If a police officer does not see a crime that happened, and then the question is there enough evidence of a crime for them to make a detention, to stop somebody, or potentially arrest somebody to question them further. I mean, it's very, very fact specific, it really is. But it's, you got two levels. You've got reasonable suspicion. Did they have enough evidence to make the stop? And then probable cause becomes, did they make, is that enough to arrest you?
A lot of times you'll hear about somebody getting stopped, and the police officer will say something like, "You don't mind if I check in your trunk, do you?"
Right.
And
Yeah, I do.
And if you say, I mind, then they shouldn't do that, right?
Yeah, right, exactly.
Careful, though. You'll wave your right and you'll say, I
and
don't
if there's
mind.
anything in plain sight, the police officer can, use that, to get reasonable suspicion, to get probable cause, make an arrest. if if you consent to field sobriety test, that's one of the things they can use that against you. If those are all things that are in plain sight that a police officer can use.
We've got Eve on the line with a question from Meridianville. Hi, Eve. Thanks for calling. What's your question tonight?
Yes, ma'am. Thank you for taking my call.
Sure.
We had a will drawn up where our children were placed as direct beneficiaries of our assets or whatever. And then I've read somewhere where they say you should place all your assets in a revocable trust, and then name your kids as benefits of the trust. So which is the better here, the will or with the direct beneficiaries of the will, or just give some insight.
Yeah.
into
Right,
where I
right.
have to go.
A few years ago was a big push, right? And a lot of advertisements for doing trust. Put your assets in trust.
Yeah.
What do you think?
It really doesn't make any sense. If you have a lot of assets, if you have a lot of beneficiaries, if you have adult disabled children, if you have grandchildren that you're providing a legacy for, that you don't know, who may be in charge of their money, trust can be a great tool. But generally, if you're just passing money down from one generation to the next generation, then you can name those people as just a beneficiary. If it is a bank account, you can be joint on the bank account, and that the one person on the bank account with you can be the beneficiary. If you have an investment account, you can typically name beneficiaries. If you have life insurance, you would name beneficiaries. Now you have to update these beneficiaries. In the case that if you get divorced, obviously, if there's a child that you don't want to give money to. But in general, there's a lot of ways you can pass down assets in Alabama without a lot of complication, and typically without needing to probate a will.
So the things that you were talking about then, putting somebody's name on an account,
Right.
leaving life insurance, that's not even going through the will. That's getting around it.
That goes outside of the estate. And the beauty of that and the benefit of that in Alabama is that what passes outside of the estate is not subject to your creditors. So we see a situation where a lot of people, they could be terribly injured. They can, go into hospital. They can have huge bills. They can have, all these outstanding debts. But if they pass away, then if they have, named beneficiaries for these accounts, all that passes outside of the estate. It's not subject to creditors' claims. And so even, if they'd had a will, and it goes to their estate, then it's subject to creditors' claims. So a lot of this is good.
Good. We're going to take a break. We've got more callers waiting. We've got more texts coming in. We'll be right back. It's Ask Us Anything night.
Brooks, which pays an advertising fee to this station.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League and Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night. At night, Michael Timberlake is here from Timberlake, League and Brooks. Good to have you here.
Well, I'm asking you anything.
Oh, okay. You got
so
one?
here we go.
Okay.
Okay, so somebody has texted us. I've got a question. If you share custody of a child as one parent and you're getting weekends, holidays, how should the taxes be divided?
Okay. So the person who's
That's
got,
not, and I didn't make that up.
No, people ask this all the time.
That's
the
great.
person who's got primary custody, we call it sole custody more so now, but the person that's got more than 50% of the time gets to claim the child on taxes unless you wrote something different in an agreement. So if you didn't say anything about it, then the person who's got primary custody gets to claim them on taxes.
So, but that's
every year.
Typically something in a divorce decree. Somebody, it's that, these are, your dependents. You get to claim the children as dependents, and the other person may get alimony, or there may be some concession there.
And if there's more than one child, or if you had, sometimes you share the children. If there's more than one child, you may say, you get to claim child A and I'll claim child B until there's only one that's still young enough to be claimed. Maybe we'll trade it back and forth. You can trade it for other things. So maybe you get more child support, but offer to let that other person get some benefit from the taxes.
Right.
So different things that you can trade. But if it's not in the agreement, then the person who's got primary custody is going to get to claim the kids every time.
And like with everybody's got joint custody these days, typically that's something that is worked out ahead of time.
You would normally put something in there that says, you take them on even numbered tax years and I'll take them on odd numbered tax years.
Oh,
so
okay.
we'll write
So
it
you
into
can
the divorce.
split it,
Yes.
Okay, great.
Back and forth. We've got Martha on the line with a question from Huntsville. Hi, Martha. Thanks for calling. What's your question tonight?
Hi.
Hi.
Back in December, I sold this old van. And a few weeks later, I get a letter from the police department that it had a switch tag. So then I get a letter from a local impound company telling me that they're going to put it up for auction. But then after that, I've been getting registered letters with an increasing fee that I owe the impound. So what do I do?
So it's a van that she sold. So you sold it. Did you do paperwork on actually selling it and do a title change and everything?
Yeah, if you got a bill of sale is really what you're looking for. And that's going to be any document that just says, I'm selling this van to you for this amount of money and it's yours.
If she's got some kind of document like that, she ought to be covered to not have to deal with these problems.
Exactly,
right?
Exactly. And at the end of the day, when you run it all the way to the ground, it's probably, she's going to, if she had a verbal agreement to sell the van, she may not be responsible for these, more than likely won't be responsible. But it's just a whole lot cleaner if you say, here's my bill of sale.
Not mine.
It's not mine.
Not my problem.
And then you don't have to change the title.
Okay.
There doesn't have to be a title transfer, just a bill of sale.
Okay. We got this email question from Glenn. Glenn says, I was in a car accident where I was rammed from the back and I hired a lawyer, but I haven't been able to make any contact with him. I leave my name and number and information. I don't hear from him. Is it common to not hear from somebody in maybe a year's time?
Types. No.
That doesn't sound right.
No, that's not correct at all. I mean, there's, especially today, we have email, we have text, we have cell phones, we have office phones, we have, people in our office that can help, and I always tell people, I say, look, I'm not going to be able to answer your call every time you call, but if I have email, you can shoot me an email, you can shoot me a text, and when I'm able to get back to you, I'll get back to you. And if you have an emergency, I've got an office that can handle that same situation. So it's, that's highly unusual that you go for a year without hearing from somebody.
So if they are disappointed with their attorney or they feel like, okay, maybe he's not even representing me, can they notify this attorney somehow and say, I'm finding a new attorney? What would
Sure.
you recommend as
Sure.
a way to change attorneys at this point?
We get people that call us and we say, look, I'm not happy with my attorney. What do you think about this situation? And there's rules of professional conduct between lawyers, and basically, if you're represented by another attorney, then I'm not allowed to give you legal advice. And so when people call us, basically I say, look, if you've got a problem with your lawyer, go sit down, talk to them, see if you can work it out. If you cannot work it out, then you certainly can terminate their services. You just have to deliver a directive, a letter saying, I am terminating your services. Can be an email or whatever. Once that has happened, then under those circumstances, then we can talk to someone about whether we can represent them or not.
Okay.
But I can't promise someone I can represent them if they break up with their other lawyer, and I can't tell them their other lawyer's bad, and those are just not anything anybody wants to do anyway. But generally, if people are unhappy with their lawyer, there's usually a reason. And first thing I say is, look, go down, talk to them face to face, see if you can't work it out. If you can't work it out, then come talk to me.
So if they brought a case to you that's already been going on for a while, and the other attorney, maybe they just got dissatisfied, it hasn't been a year like this, but the attorney has done work on the case.
Sure.
And now they fired that attorney and they're bringing it to you.
Right.
What happens when you finally do resolve this case?
Well, there's a statute that says that the attorney that had the other case, if it's a contingency fee agreement and they haven't been paid on, or they haven't taken a retainer and then taken a draw off a retainer, if it's contingency fee like we handle in injury cases, then they get a chance to make a claim against any recovery for their time in the case. Now, that's always a question of what did they do, what did they not do. If they got fired, they may not have done a lot of work, but that's something that we typically work out with lawyers. And if somebody's done work, we want to take care of them.
Yeah. Let's talk a little bit about the actual trial process and how many cases go to trial.
Sure.
So personal injury kind of cases, so that's auto accidents, medical malpractice, the kinds of things that you do. How many of them actually go to trial, and what percentage would you say get settled?
Well, I mean, it's really kind of a loaded question because it depends on the genre, the type of case. Most medical malpractice cases that are filed in Alabama go to trial. That's just the way it is. The defense wins the overwhelming majority of these cases. They're difficult cases to present. They're expensive to present from the plaintiff's perspective.
And when you're saying the defense wins, that's like the doctor and the
doctor,
doctor's
the
lawyers
hospital,
typically win.
There's typically a defense verdict.
Okay.
They're very complex. They're very hard. So if you're looking at those kind of cases and someone wants to take one of those on, they're going to be a damn good lawyer and they're going to know what they're talking about because they're expensive, and if you lose a lot.
Okay.
Then you flip it to, say, car wrecks. If it's a situation where there's not a question about who's at fault in a car wreck, more than likely that is the case. It's going to be settled 80, 85, 90% of the time.
Without a trial.
Without a trial. You're going to settle, you're going to get involved in litigation in a car wreck case if there's a question about who's at fault, were these injuries caused by the wreck, is there enough insurance, and we file more cases because we don't think the insurance company's offering enough money, and we fight them over that, and then we work up the case and we build up the case, and then at the end of the day, they usually pay us.
They take you seriously once you've done that.
But we don't, those cases may not get tried, but they certainly get filed.
We're going to take a break. We'll be right back answering your questions. It's Ask Us Anything night. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake. Timberlake League and Brooks, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon practices family law right here in the Tennessee Valley. She does a great job with all things associated with child custody, divorce, those types of things. 256-539-7337, www.sharonfamilylaw.com.
We always talk about statute of limitations and how long you have to do things. When a child is injured, does that change your statute of limitations for bringing a case?
Typically, the statute of limitations for somebody that's injured is 2 years from the date of the injury.
Okay.
But if it is a minor, somebody that is below 19 years of age, then they have 2 years from the date of their 19th birthday. So it can extend a long
time.
Yes.
Okay. Thanks for all your questions. See you next week.